with the right jury, you can't lose a case. With the wrong jury, you can't win a case. You're trying the case to the jury. So yes, judges have influence. Federal judges have significant influence, but it's the alpha and the omega of trial work is cutting the right jury. People, again, the misnomer is you're selecting a jury. No, you're not. It's a process of elimination, right? There's a thing called the peremptory challenge, which means you can get rid of them for any reason at all. In Texas state court, for example, you get a finite number of peremptory challenges. Same in federal court. The government gets 6, the defense get 10. And if I don't like that guy's shirt, that lady rolled her eyes. She drives a Subaru. I don't like women that drive Subarus. Sorry, whatever. You can get rid of them for any reason other than basically race, right? You can't. There's a thing called a Batson challenge where if you believe the other side has eliminated a juror simply based upon race, you can challenge them and they prove whatever. You get a finite number of peremptory challenges. Then there's a thing called challenge for cause if they can't follow the law. If it's, for example, if it is an aggravated sexual assault of a child case and you have a person who was sexually assaulted as a child or who husband was accused of it or what have you, and they could never afford the presumption of innocence in a sexual assault of a child case, right? They can't follow the law, so you can challenge them, and the judge should excuse them for that reason if they have a bias or prejudice against any law that's relevant in the case. So it's the first 12 that survive. It is not the 12 that you pick. So what I'm looking for in a case is totally dependent upon the kind of case I'm trying. A jury that I would pick in a white-collar case is completely different than a jury that I would pick in a self-defense murder case. A jury that I picked back in the day on a DWI is completely different than a jury I'd pick in a PPP fraud case these days, right? You're looking for different things because you have different pieces in the trial.
What's interesting to me is that I feel like sometimes your process, or you and Haynes, it's so counterintuitive. Like, for example, on the Carrie B case, you got an all-female jury, but if you look at the comment section of our videos when we talk about Carrie B, they think of that as like an even more difficult, he got a not guilty, or he got him 10 years when the jury was all female. So it feels a little bit counterintuitive, but it ended up working for your favor. So can you explain that a little bit?
Sure. Like in the defense in that case was not that he didn't do it or that she had it coming, right? The defense in that case was that he was enraged based upon comments she had said and things she had done, right? And women are harder than women on women than men. They just are. I mean, if a woman, next time you're out to lunch or dinner with your girlfriend, your significant other, and a woman comes in, just watch the way whomever you're with sizes them up, right? And they're going to be, look at those shoes. Are you kidding? That really they are harder on women. I don't know why that is, but they are. And so in Carrie's case, we believe that because of the awful things, again, just didn't make the killing justified, but she said terrible things about Carrie's financial ability to provide, about his ability to satisfy her sexually, that we thought a woman would react to that more negatively than a man. And also, we believe that if a man got on there, he would be a quienes mas macho. No man should ever do that. He should be punished. He should be lit up. And so we didn't want to have. We either wanted all women or as few men as we could get. And yeah, it's counterintuitive, but not when you step back and think about the reality that the defense was kind of not that she had it coming, but she had some terrible things to say and terrible things that she did, and that's going to upset men.
So when you say are you like in agreement with that, or is there usually like a convincing between the team that's involved where you're like, hey, this is why I feel like we should have an all-female jury, and then maybe somebody is like, no, well, I think men will be just as upset or something like that. Do you have to like convince, or or you guys are
the-
usually all in agreement?
It's the lead lawyer's job to decide. And there's a couple of great jury. Look, Lisa Blue is a jury consultant in the state of Texas who's great. Robert Hirschhorn is my friend, and I love the guy. I've worked with him for 2 generations. He's just awesome. Jason Bloom. There was some really good jury consultants. But what you'll try to do, if the circumstances allow it, is do a focus group or a mock trial. And fun fact, Robert Hirschhorn, who's sort of my go-to guy, jury consultant that I've worked with for forever, he has now incorporated AI into focus groups and mock trials. So what Robert can do, and it's called Verdict Hub, what he can do is assimilate through artificial intelligence. If you say, I'm trying a rape case in Waco, he will have a artificial Waco jury pool that you can try your case to, and they run it through AI, and you can process, how this person reacted, how that person, how this theme, how that theme. And that's a gross oversimplification of it. But my point is, most focus groups would run you anywhere from like 75,000 and up. So you can spend.
Can you? And I'm sorry to interrupt you there, but can you explain why it costs so much?
Sure, because in a focus group, what you're doing is you're killing one day, usually 2.
Yeah.
You're paying, 50 people.
Yeah.
You got to pay them to show up, right? And you pay them $200 a day or whatever it is. So that's a fixed cost of $7,500, $10,000 or whatever. You got to rent a hotel space to do it. So that's another $6,000, $8,000, $10,000. You got to pay Robert's folks, and you got to get them lunch, and then you pay for his expertise, his experience, his analysis, and all that. So all of this stuff adds up real quick.
Yeah, that makes sense.
And on these big boy civil cases, that's nothing. But in my little dirty fingernail criminal defense world, not a very small percentage of my clients can afford that. So now and Robert's not the only one, but with Verdict Hub, you can put in the particulars of what you're looking for, and an AI jury from Waco is going to look different than an AI jury from Longview, is going to look different from an AI jury in Houston or what have you. And then you test the theories. You proceed through it, and you get analytics at a fraction of the cost. We're talking $3, $4, $5, $6,000 as opposed to $40, $50, $60, $70,000. And I'm convinced that Robert's convinced it's the wave of the future, not only in terms of efficacy and efficiency, but cost as well. So it's a fusion of what we were talking about the other day about AI and jury selection courtroom work.
That's so interesting. So in the Carrie case, did you guys do that? Did you guys have a mock?
We did not.
So you went on the fly and you were like, hey, this is what I believe?
Well, look, in Carrie's case, the alpha and the omega, to use that tired expression one more time, was that video, right? There was no really testing of theories. There was no some other dude did it, or the gun went off accidentally, or I was, it was what it was. So we had fewer areas to analyze, for lack of a better description, than you do in a lot of cases.
What I was going to ask was the balance of like your gut instinct versus like strategy when you're doing this, right? And what AI can't do is it could help you strategize, but it doesn't have instinctual, decision-making skills. So how much of that is just instinct that's driving your decision, or is it really formulaic and strategic?
It's both.
Yeah.
At the end of the day, I'm going to go with instinct over analytics.
Yeah.
Just whether that's the right reason or the wrong reason, I'm going to do it. But it's both. And my gut after doing 2 or 3 or 4 focus groups or 2 or 3 mock trials, my gut's going to be different than before I did those, right? But at the end of the day, it's my responsibility, and I've got to live with the consequences. So I'm gonna lean on me.
There's obviously a psychological and strategic, depth to jury selection, and reading body language, asking subtle questions, all those things are super important. And a popular trial that we've talked about, Johnny Depp versus Amber Heard, there's a lot of scrutinizing, the composition of the jury. Like, what's the sneakiest question you've asked to uncover a juror's bias?
Look, there's all kinds, and to step back for just a second, and I'll answer that question. Yeah. Look, you're doing a bunch of different things during jury selection, right? you're pitching your case, right? You're establishing credibility. You're trying to gain information about who these people are and how they're gonna react. You're trying to pitch your theory of the case, right? Self-defense, or they had it coming, or some other dude did it, or whatever. There's a bunch of moving pieces that are in play all at once. So, right? So it's just not one or two ingredients going into that stew. It's 8, 10, or 12 of them. So there's a bunch of different things you're trying to accomplish. But in terms of sneaky questions, I don't know how sneaky they are, but you'll want to. I like to ask questions about, do you make your decisions very quickly, or do you make your decisions over a period of time, right? Which tells you an awful lot, right? I like to ask silly questions like, what's your favorite television show? Well, if it's CIA or CSI rather, that's a different genre than America's Got Talent or whatever. You try to find out what's important to them, right? Where they get their, what's your favorite source of news, right? The person that watches CNN is going to be a different genre than the person who watches Fox. Do you live alone, or do you live? You want to find out as much as you can, because I don't think there's really a single piece of information, unless it's directly on point to a disputed fact in the case. For example, I used to think to myself, I never want engineers, right? Because there's no flexibility in their analysis, and they're always going to just tab A going to slot A and all that. I never want bankers. I never want insurance people. All that stuff is out the window in my view these days, because it depends upon the case. So again, Aaron, that's a windy way of saying I don't think there's a really sneaky question. I just want to get as much information. I want to know as much about that person as I can, and how they are reacting to me, right? Oftentimes it's not even what they say, it's how they look at me, how I engage with them, or vice versa. If somebody drops their head, throws their eyes back, looks down, I'm probably not their favorite guy, right? So how I'm reacting to them and how I perceive that they're reacting to me, that's a huge part of it. Because I'm the medium, right? I'm the salesperson. I'm not the product, but if you don't like the salesperson, you ain't buying the product.
Just if you, off the top of your head, how many different jurors have you interacted with in your lifetime at this point? Thousands?
Thousands.
So you've picked up on a lot of these like little
and you pick up on them. It's just like anything else. If you play 500 basketball games, you're going to be picking up on things you're not even aware that you're being picked up. They just become part of your nature, right? And it's the same with trying cases. It's just repetition. At sooner or later, if you're doing it right, is the only path towards excellence. And I do a lot of things, I think, cognitively, but I'm sure I'm doing just as many things subconsciously in terms of making a decision about this person, that one, this one's good, that one's bad.
Do you think there is a line between being strategic and unethical, or excuse me, where is the line between strategic jury selection and maybe unethical manipulation?
I've never really thought about being unethical or manipulative.
Is that something that's a common practice for some lawyers?
I don't know.
Yeah.
I want to find out let me answer it differently, or answer a different question. 10 years ago, the idea of crawling around in somebody's social media and finding out how big their house is, or what they voted, or whether or not their kid was ever in trouble, or anything along those lines, or 20 years ago, that would have been, oh my God, you're invading their space, and that's a terrible thing to do. You don't have the right to. Now, it's done every day. There are programs out there that spit you, that you can tell exactly what primary, how long they've lived in the house, whether or not there's a lien or a mortgage on the house, how many times they've been married, how many kids they got, and it's almost ineffective if you don't try to find out that information, because again, there's not one thing in a person's life that's going to give you a clear path to whatever decision they're going to. We are all a creature of all our experiences, so you want to find out as many experiences as they've had.
This might be a stupid question, but
leave that up to me, man.
Yeah, you said it a couple of times, so I'm like, I gotta say it too. How often is it where a jury will not dislike the lawyer, so then they're just not going to be favorable.
Oh, I think it's frequent.
It's frequent.
Absolutely. I heard, it's been 4 or 5 years ago, Tommy, Jeff Kearney and I, brilliant lawyer, one of my best friends, love the guy. We tried a case in Sherman, Texas before Judge Mazant, who's a wonderful judge.
At Austin College, we went to.
I love Judge Mazant, one of my favorite judges, one of my favorite people. And he's just a lovely guy and does some cutting edge stuff. I just adore him. I think he's wonderful. Did you hear that, Your Honor? Anyway, really, really good judge. But we tried this case, and we tried it. There was a mistrial, got another trial, tried that and lost it too. But I heard this woman, one of the jurors, because in federal court, most judges will not let you talk to the jurors after the case, right? And I heard this, one of our jurors being interviewed on a podcast like 6 months after the trial, and dude, she hated me. Yeah. I mean, just was eviscerating me at every level, you know. Who's that fat guy? I couldn't stand it when he opened his mouth. I would never vote. I mean, it's like, dude, that's harsh. But and I say that not to brag, but to your point, that woman's dislike for me was so strong that I would guess so wrong on her, and she couldn't stand me. So I've also had the episodic case where from day one I had an engagement with that juror, and he or she and I got along the entire time. I knew that I had them in my tent, and I was trying the case to that person, and I was looking them in the eye, and I was, it absolutely matters what the relationship or what the impression of the juror is. And asking a question you didn't know the answer to, or didn't ask, rather, I'm sure you knew the answer, you just didn't ask the question. To me, the second most important thing, besides picking a jury, is the opening statement. Because studies show that 85% of jurors will make up their mind after the opening statement, right? So the rest of it is just confirmation bias. They're just looking for evidence that supports their decision. They're not waiting to make the decision. They've already made the decision after opening, and they're just looking for the things that support their position. Do I believe it happens 85% of the time? I don't know. But it damn sure happens, in my opinion, more than 50% of the time, because it's just confirmation bias. They come to a decision, then they look for the information that supports that decision. So as much as we talk about the significance and importance of jury selection, which it is, opening statements matter for sure.
So if that's the case, then when you're prepping, like what is your process or top maybe 3 bullet points you can give us in building a strong opening statement?
That's a good question, but let me temper. I keep avoiding your question. I don't mean to.
No, I don't. Just take it where you think it should go.
I just want to. So, as important as opening statements are, I think the longer the trial, the less important the opening statements are, because primacy, recency, right?
Yes.
And some of these trials that are a week long, okay, opening's important. A 2 or 3 day trial is critical, right? Because you're going to be arguing what you just said. At the end of a 6-week trial, you're going to be arguing something nobody remembers what the hell you said. So the most important, I don't even think there's 3 things. I think it's one thing. What I need to do in opening statement in a criminal case is explain to the jury why my client is not guilty. Right? They need to have an understanding of what my defense is, and that sounds, academics, stupid, sophomoric, whatever, and all those things apply. But I have heard opening statement after opening statement after opening statement from both the prosecution and the defense, where the government never tries to explain exactly why the accused is guilty, and even more often, you have a defense lawyer up there who never he attacks the credibility, or he talks about the presumption of innocence, or he talks about the burden of proof, and all those things matter. But at the end of the day, I'm sitting there listening, going, well, you never told me why your client's not guilty, right? And so that is my goal: is for the jury to understand why I believe and why the evidence supports the fact that he's not guilty. And even if that theory is just they can't prove it beyond a reasonable doubt, or you will have they need to understand that too, right? So thing number one, thing number two, and thing number three, to put it back in the parlance of your question, is they need to know why my client's not guilty.
I love that. And to just carry on with this line of thought before I finish off with some jury-related questions, you say the opening statement's important. It almost is, loses its significance the longer the trial goes. Have you ever had a time where maybe you felt like you were losing the room throughout the trial? You might feel like this is not going in my direction, and then you saved it with like a banger of like a closing argument?
I think any lawyer that says he's won a case in final argument, I think that happens, but I think it's very rare. I think you can lose a case in final argument as a defense lawyer more often than you're going to win a case. And I love my final arguments. I just love the crack of my voice in final argument. And I'm being a little bit facetious, but I'm good at that. I can deliver. I can cross and open and close with the best of them. Are there better lawyers in terms of cross-examining an expert or putting on a compelling direct or what have you? Bet. But those three primal areas or prime areas, I think I'm pretty damn good at. But I have, I don't think I've ever won a case that I would not have otherwise won in final argument. Based on my final argument, I think I've lost a couple where a prosecutor comes in and just cleans the clock and I got nothing left to say, right? Because as most people know, the government has the burden of proof. So in final argument, they'll do a quick opening, right? And then you argue and they get to close. So they get to open and close in final argument, which is terribly unfair to me, but they get to do it. So, if I don't bait the government into saying some things, or if I don't take them out of their game, and that's really half the job in my final argument, is get the government to answer this question and make sure it's a question they can't answer properly, what have you. I try to bait the opposition in my final argument to suck some of the wind out of their sails, because otherwise they're going to roll right over me, right? So I've lost some cases probably, or I've contributed to the loss of the case when I didn't effectively blunt what was coming. And that's really part of the art of the deal in final argument. It's not to just get your pitch, but to destroy theirs.